Hello. A while back, I was in a YouTube comments debate over the issue of default shared custody, and I was absolutely astounded by the lack of understanding displayed by two individuals who I will not name. Currently, in divorce courts, at least in the US, if there's a dispute over child custody, meaning the parents cannot agree on an arrangement, the courts will typically rule that one parent is the primary custodian, while the other typically gets either visitation or limited custody time. The proponents of default shared custody would discourage the courts from ruling in favor of one parent over the other, and instead would have the starting point be a 50-50 custody split. Now, there are many misconceptions about what default shared custody is, how it works, and what its practical implications are. Unfortunately, many of these misconceptions are spread by certain groups that make a point of opposing default shared custody. One such group is the National Organization for Women, or NOW for short. I'm going to be reading a statement put out by the New York chapter of NOW and explaining how and why they're wrong. Links to this statement, along with all documents and studies I reference, will be in the description if you wish to examine them for yourself. Please let me know if I accidentally leave anything out. NOW's statement is regarding a New York bill that has been essentially stuck in limbo for the past decade or so. They start off by describing the intent of the bill and defining the term shared custody. The bill is described as seeking to create a statutory presumption of joint custody for all minor children whose parents are no longer married, so that both parents can continue to share in the responsibilities and duties of a children's upbringing. I do have a slight issue with that statement, but let's first hear the definition of shared custody. Shared parenting is the award of custody to both parties so that both parties share equally the legal responsibility and control of such child, and share equally the living experience and time and physical care of and ensure frequent and continuing contact with both parties as the court deems to be in the best interests of the child, taking into consideration the location and circumstances of each party. Now here's my problem with the way they describe the bill. They fail to mention that this bill would only affect child custody disputes. The way they frame the bill makes it appear to affect all divorce cases, no matter what, which is simply not the case. Next, NOW starts to make its arguments against the bill. It starts with the assertion that shared parenting is in the best interests of minor children, is on its face untrue and directly contradicted by the body of academic research on the subject, as well as the disastrous experience of California, one of the first states to adopt this experiment. Now, there are several problems with this sentence, the first being that they make claims with absolutely no supporting evidence. They provided no citation to demonstrate this body of academic research. So I decided to do their work for you and research the subject, and I found two extensive studies on shared custody versus primary custody. The first is a study conducted in 2002 by Robert Bauserman entitled Child Custody and Joint Custody versus Sole Custody Arrangements, a meta-analytic review. Unfortunately, the study itself is behind a paywall, so I only have access to the abstract and the references. According to the abstract, children in joint physical or legal custody were better adjusted than children in sole custody settings, but no different from those in intact families. That alone seems to refute NOW's claims that joint custody is not in the best interest of the child. Regardless, I did also find another nice study by Jan Turunen. This one is actually free to access. This particular study examines stress levels of children in both sole and default custody arrangements in Sweden. I'd like to point out that the paper makes sure to justify the distinction between joint legal custody and joint physical custody. Joint legal custody is when both parents share equal decision-making responsibility, and joint physical custody is when the child actually lives with both parents. The study focuses primarily on joint physical custody rather than legal custody. It's also worth mentioning that as of 2011, Sweden has the highest rate of children in shared physical custody in the world. What makes this study stand out in particular is that it's one of the most comprehensive studies on shared custody out there. Turunen mentions that it's difficult to analyze previous Swedish studies due to the fact that many of the sample sizes were non-random, and there are inconsistencies in defining joint custody, with different studies having different thresholds for differentiating between primary custody and joint custody. But the data they collected was via in-person interviews from Statistics Sweden. Children aged 10 to 18 were also interviewed so as to get the perspectives of both parents and children. In the case of a parent's interview contradicting with a child, it's assumed that the child understands their emotional state better than the parent does. There's also a lot of information within the study that's very interesting, but it's not vital to this video. To sum up the findings, children in sole custody arrangements were more likely to be highly stressed than those in joint arrangements. In Turinen's words, we can thus conclude that having equally shared residence is associated with markedly lower likelihood of stress for the children. It's also worth noting that the paper claims to control for variables such as parental conflict, though unless I missed it during my read-through, it was not explained how this was done. Overall, I think it's safe to conclude that Now's claims about an academic consensus in favor of sole custody can be dismissed as complete bullshit until they can provide some supporting evidence. Now on to the next problem in that first sentence. You'll remember that Now referenced California as having a disastrous experience in regards to shared custody. Not only could I not find any evidence supporting this supposed disaster, but California does not actually have a presumption of joint custody over sole custody. I took a look at a few analyses of Californian custody law, and I found that it's actually very flexible. California does have a predisposition to enforce joint legal custody of the children. And to be clear, this predisposition does not mean that the law encourages judges to specifically rule in favor of joint legal custody. It's simply the most common ruling among judges in custody disputes. Furthermore, as mentioned previously, joint legal custody and joint physical custody are two vastly different things, and the New York bill focuses on joint physical custody as opposed to legal custody, making this a flawed comparison even if there are complaints of California's disastrous experience were substantiated. California judges are actually told to consider many variables in custody decisions, including histories of abuse, the child's wishes, and the relationship between the parents. One thing that the law does encourage is the continuance of the status quo, which is defined as any custody arrangement, be it informal or contractual, that has been followed for any significant amount of time that hasn't been shown to be problematic for the child. The law dictates that the burden of proof shall be on the parent who is attempting to break the status quo. There's literally nothing in California custody law that enforces default shared custody. And I think it's safe to say that Now's reference to California was either a lie, the product of being too lazy to do proper research, or the result of someone being too stupid to understand the data in front of them. Next statement. To arbitrarily reassign a child's primary caregiver or to disrupt the child's attachment to a primary caregiver creates an unstable and even traumatic situation for the children. Again, no citations in sight. Also, notice the sneaky use of the word arbitrary. That implies that default shared custody doesn't actually have a point, which it does. Not only does it allow both parents to actually be parents, it allows the child a chance to bond and maintain relationships with both parents. That's far from arbitrary. Now's not exactly being very honest here. Also, they assume that allowing for shared custody will disrupt the attachment to a primary caregiver. First of all, there may not have ever been a primary caregiver, as when two parents live together as a married couple, they tend to both see their children fairly often. Also, I fail to see how allowing both parents an opportunity to raise their child will disrupt any relationships whatsoever. If anything, sole custody is the decision that will objectively hinder a child's relationship with one parent, especially if the other is uncooperative in allowing access between the child and their parent. Next statement. Increased father involvement does not necessarily result in positive outcomes for children. The involvement by the father will have positive consequences only when its arrangement is the choice of a particular family and when there is a relatively cooperative and low conflict relationship between the parents. It's interesting because it's the first time Now starts using gendered language. Before, they had always talked about the parents, using the word parent. Now they're starting to use the words mother and father. I'm not sure exactly what this means, but it's interesting nonetheless. But notice how they assume that the mother is naturally the superior parent, and the father is little more than an accessory in the child's life. Now, of course, a child will be happier if the parents get along, but that doesn't mean that arbitrarily choosing one parent over the other is the best solution. Plus, mothers aren't always the better parent. Any system that assumes so is inherently flawed. Next statement. In families where there is high level of conflict between the mother and father, joint custody arrangements are harmful to children, placing them in the middle of ongoing bickering and a stressful, unstable environment with no escape. As opposed to leaving them with one parent who will incessantly talk shit about the other. Also, I'd like to share a quote by Christopher Hitchens. That which can be asserted without evidence can be dismissed without evidence. Now, I know this quote has become a cliche, but it's absolutely true. now makes many bold claims within this statement about shared custody, and not a single one has any evidence to back it up. I have only their word for it that what they're saying is accurate, and quite frankly, I don't trust their word one bit. Next statement. Where there is domestic violence, joint custody arrangements are never appropriate. Well, duh! Good thing the bill you're lobbying against doesn't enforce shared custody in cases of abuse. Default does not mean mandatory, which is abundantly clear in the bill itself if you'd even read it. Next statement. Legislating shared parenting will not make it so or guarantee continued relationships between fathers and children. Now that's not really a critique of shared parenting itself now, is it? It's really more of an indictment on how the custody arrangements aren't really enforced. Now, I fully believe that the law needs to take custody arrangements more seriously and that there absolutely should be a way to ensure that your custody agreement is kept with the help of the police rather than you being forced to go through lengthy court proceedings. Just because it's not well enforced doesn't mean the concept of default shared custody is flawed. That's just a stupid assertion to make. Next statement. Joint custody bills have been designed to establish rights without responsibilities. Joint custody facilitates using the children to maintain access to a former partner and ongoing control of their life. Fathers' rights groups continue to push for legislation in spite of the body of evidence that in the majority of cases, joint custody is not in the best interest of the children. Alright, first of all, bull fucking shit. The first thing the bill says, the very first line, is the legislator hereby finds and declares that it is the public policy of the state to ensure minor children have frequent and continuing contact with both parents after the parents have separated or dissolved their marriage, and that it is in the best public interest to encourage parents to share the rights and responsibilities of child rearing in order to effectuate this policy. How the hell do you get the idea that it establishes rights without responsibilities when it specifically mentions that both parents get rights and responsibilities in the first line of the bill? Also, what body of evidence are you referring to? In my own personal research, I can only find mountains of evidence suggesting that joint custody is in fact better for the children. Just saying that there's a body of evidence to support your claims does not make it so. You have to show us what evidence there is. Next statement. Fathers' rights groups continue to promote the myth that courts are biased in favor of the mothers. In litigated cases, fathers who sue for custody almost always win. In fact, fathers are often awarded sole custody even when the sexual and physical abuse of the children is alleged and substantiated. According to the American Judges Association, 70% of the time the abuser convinces the court to give him custody. Finally, an actual lead to examine. Unfortunately, it left me very unconvinced. Before I get into what the American Judges Association says, I'd like to point out the deceitful way this information was presented by Now. This section of Now's statement is about child abusers, while the AJA's statement is about partner abuse, which is a pretty important distinction to make. Furthermore, this admittedly short rabbit hole stops dead and the only reference I could find to the 70% figure, which is located on the AJA's website, which is linked below. The statement itself reads, "Studies show that batterers have been able to convince authorities that the victim is unfit or undeserving of sole custody in approximately 70% of challenged cases." You know, I hate that term, studies show. It's a way to give your argument legitimacy without actually providing any real evidence. As the AJA did not provide any links to any of these supposed studies, I cannot substantiate these claims, and I cannot check the parameters of the studies. What defines a batterer? Does there only need to be an allegation of abuse, or does that allegation need to be somehow substantiated? After all, child custody law tends to dictate that abusers do not get custody of their children. Also, Now implied that in these cases the abuser gained sole custody of the child when in fact, according to the AJA, it's actually that the victim just didn't receive sole custody themselves. I'd also like to point out that a simple allegation of abuse towards a partner or the child should not be taken into account in a custody decision. It certainly grounds for an investigation into the alleged abuse, I should say. But sometimes people lie. If a parent knows that they can get guaranteed sole custody by lying and saying that their partner abused them or abused the child, people will take advantage of it. Obviously not everybody, but it only needs to happen once. The concept of innocent until proven guilty should always apply. A parent should not be considered an abuser by the courts based solely on the allegation. Also, I'd like to plant a great big citation needed on Now's claims that these allegations of abuse are substantiated. No court will regularly allow a child abuser to have sole custody. Next statement. Existing law currently says there is no preference for shared parenting in New York. The court may award joint custody, but in practice rarely does so. Legislators should be aware that the reason that more mothers have custody after divorce is that most arrangements are worked out between the parents. 95% of the litigated cases, including matrimonial cases, are settled out of court. Now here's another common misconception about default shared custody, and one of the most prevalent too. It's the idea that it will stop parents from mutually agreeing to a sole custody arrangement. That claim is a load of crap. Default shared custody only applies in cases that actually go to court. From Section 2 of the bill itself, the burden of proof that such shared parenting would be detrimental to such child shall be upon the parent requesting sole custody. The court shall determine solely what is in the best interest of the child and what will best promote the child's welfare and happiness and make award accordingly. That right there sums up what default shared custody is all about. It's not about forcing arrangements on parents. It's not about keeping a child with an abusive parent. It's the idea that if a parent wants to keep a child from being in the other's custody, they need to have a damn good reason for doing so. Why is that such a radical concept? And now for the final argument. Legislation providing for mandated joint custody ignores the issues of domestic abuse, including child abuse. Mothers are too often held more accountable by child protective services for child abuse perpetrated by the father than the fathers themselves are. Mothers are often accused of parental alienation syndrome, which discourages women from protecting their children, since raising the issue of child abuse leads to retaliatory accusations of alienating the child and frequently to an award of custody to the abusive father. Again, citation needed. How could you possibly know that CPS falsely blames mothers for abuse perpetrated by fathers unless you're working under the false assumption that women never ever abuse their children? Also, how could you know that these allegations of alienation aren't legitimate? There are disgusting people out there who will use child custody as a weapon against their partners. You're assuming that all abuse is perpetrated by men, that mothers are falsely blamed for it, and that all allegations of alienation, or at least most of them, are false. I'm not accepting that as truth without some sources to back up, which were conveniently left out again. Now, that's the end of the major body of Now's statements. And I hope this helped clear up some of the misconceptions about default shared custody. I think it's absolutely deplorable that groups like Now will fight against legislation that aims to provide children with access to both parents. And they're not even doing it for any kind of practical reason. They're doing it purely for ideological reasons. I have serious doubts that anyone at Now has even read the bill. Many of their statements contradict what's actually written down within it. Now, I'd highly recommend that you read the bill itself and read some of the other sources I linked down in the description, because it's not only very interesting, but it's a very important discussion that needs to be had. Now, I'd love to hear your thoughts, and if you have any additional information or criticism, that's always welcome too.